Hey, good morning. This is Legal Bytes. I am filling in for our normal host, Jim McCoon, this morning. And we are delighted and fortunate to have Mr. Mark Young with us today, who is an expert in debtor-consumer bankruptcy and is going to walk us through all the intricacies of bankruptcy under our current Bankruptcy Act. Mark, we're delighted to have you. Mark has been practicing exclusively bankruptcy for probably more years than he would like to tell us. His office is at 2121 Hamel Road. He is certified in debtor-consumer bankruptcy, which is a real specialty. And Mark, we're delighted to have you. Appreciate you being with us.
Thank you, Fielding.
And let me just start with sort of a real fundamental question. Years and years and years ago, in my general practice, I used to do file occasional Chapter 13 and an occasional Chapter 7, which we will talk about. And then Congress got around, I believe, in 2005 to amending the Bankruptcy Act. It made some significant changes. And for me, as a practitioner, it just wasn't worth it to go down there because I didn't have the volume. But one of the real fundamental questions that I always dealt with, and I guess it's a good place for us to start, is when do you need to consider bankruptcy? While Mark begins to talk with us, if any of you listening today have questions, our call-in number is 423-800-8949. Please give us a call. Mark will be happy to answer those questions. Mark, when does one person need to consider bankruptcy as an alternative?
Well, I guess feeling when I say my practice is better too early than too late. And so I would say to someone, if you're handling your financial debt problems at home and can have them under control, that's fine. When things start getting out of control, when you can't pay your debts as they come due, especially if you're getting threatened with suit or being sued, or certainly if you're being garnished or you're getting behind on your car or your house, definitely at that point, it's time to come talk to someone. Most attorneys in this area don't charge people for an initial consultation. I know we do not. And it's good to know your options before you have to use them, rather than maybe wait too late after. Once their house is foreclosed on, we can't help them.
Once the house is gone, it's gone. That's what you're trying to tell me.
And it's a little different answer on a car, actually, but once the sale on the house occurs by foreclosure, we can't really go back and do anything about that. But if a client calls me today and says my car was repossessed yesterday or 2 or 3 days ago, if they have an income, we can actually usually file a 13 and get the car back. That's anyway.
All right. Now, what have you found to be human nature about, do people procrastinate dealing with their debt problems?
Well, I think like most of us, we tend to put off things that are problems that we don't want to deal with, and people tend to wait to the very last minute before they come in to see us, and often they're very relieved that we can help them. Most of the time, there is an answer under bankruptcy, not in every case, but the majority of the time, there's something we can do to help them.
Now, let me ask you a question. I know you hear sometimes a lot of advertisements about the people who have a lot of credit card debt and can go to some consumer credit agencies and help consolidate the credit card debts. Is that an alternative to bankruptcy, or how do those things work in your experience?
Well, there's one here in town called Consumer Credit Counseling. That's part of Family and Children's Services. And I recommend people go to see them if it's something that can benefit them. They're very legitimate. They're a nonprofit. They help a lot of folks. So I know they're a legitimate way to deal with debts for a lot of people. And there are a lot of these people companies that advertise on TV and radio and everything like that. Some of those companies are very legitimate and do a good job. And some of those companies have taken advantage of people. I don't have a list of the good and the bad, but I would say you have to be careful and vet them. So that will hurt your credit some. Is that a good answer? For some people, it may be, and sometimes it's just putting a Band-Aid on the situation.
Now, let me ask you a question. I know you hear a lot about in bankruptcy, the main alternatives, or what they talk about, Chapter 13 or Chapter 7. What are the differences, and what things do you look at to determine which one a particular debtor would need to consider?
That's a good question. When we say Chapter 7 and Chapter 13, those are actually chapter numbers under the Bankruptcy Code. And Chapter 7 is what people think of generally as just filing bankruptcy. That's where they file and discharge their debts. There's some things that aren't discharged, but you can discharge uh, uh, medical bills and credit cards and general signature loans and things like that, and wipe out your debts. And you can keep your assets up to a certain dollar amount. There's a dollar amount of assets you can keep. Have a lot of medical bills and credit cards that are out of control if they don't have too many assets. Chapter 13 is a repayment plan. It usually runs for 3 to 5 years, and that's designed primarily to help people that are behind their house and their car. They can save their house, save their car, and pay their other debts. They don't necessarily have to pay all their debts in full, but they can pay what they can afford. And usually a 13 is a good solution if Chapter 7 is not.
Now, let me ask you a question. Is there now under the current act, is there some sort of means test about if you have too many assets or too many means about filing a Chapter 7 as opposed to 13?
Yes, Phil. Before 2005, we didn't have the means test, and Congress, in their infinite wisdom, made 500 pages of changes to the bankruptcy code in 2005.
See, that's why I got out of bankruptcy right there.
You're a wise man, Phil. But they implemented something called a means test. And of course, in bankruptcy, a concept's always been there of what's disposable income. And simply that means if you look at someone's income and their reasonable living expenses, what theoretically is left over at the end of the month to pay on their debts? Is it $100 or $800? And certainly it makes sense that they should pay what they can afford to pay. And usually that was just done by simply looking at their income and expenses. But Congress designed something called a means test, which is a mathematical formula that's based part on reality and part on assigned values. It's kind of complicated. And that applies to determine disposable income. Family or the household I'm talking to, if their immediate income is above the median, if their average income is above the median, in other words, if they're in the top 50% of earners in Tennessee, to determine their disposable income. If they're in the bottom 50%, we just look at reality. And that doesn't make a lot of sense, but that's what Congress has come up with. And the means test first will determine if they make too much money to qualify for a 7. If they just make too much money, they do not qualify for a 7. And then they would be required to file a 13. And it would tell us how much they pay to their unsecured debts. Unsecured debts are generally like medical bills and credit cards and signature loans. And the means test, they come up with some number like, say it's $100 a month as their disposable income. Well, if the plan is going to last for 60 months, if it's a means test case, so you take the $100 multiplied times 60, and that's $6,000. So they then pay $6,000 toward their unsecured debts, and the balance is discharged. Because Congress has said that this is a good measure to see what they can afford to do. As long as they do that, the rest of it will be wiped out. Maybe they have to pay 100%, 2%, and that's how that works.
If you found there to be rubs between what people, the actual reality and how it applies to the means test.
Yes, the means test is somewhat fair, but there are, like anything else, you can't have a mathematical way to measure someone's universally fair and equitable in every situation. It kind of tends to discriminate against a 1 or 2 person household, people without children. It's sort of fair, but not fair in every circumstance. There's a lot of unusual things about it that vary from person to person.
For example, if you don't have children, you don't have the same expenses that
right.
you would if you did have a house full of children.
Yeah, there's a lot more allowances for larger families, and if you own property and have more secure debts, you get more deductions. It's I don't know, it's a lot of rules, and sometimes it's more favorable to one person than the other, although it tries to be fair to all.
Now, have you found situations, before we go on, where people have wanted to file a 7 and just really haven't been able to, and have had to convert to some form of 13?
Yes, a lot of times people come in, and one reason they would not be able to file a 7, one is the means test. They may make too much money. The second thing, and a common problem, is they may have too many assets. So if you file a 7, you refer to state law. Bankruptcy is federal law, but state law determines how many assets you can keep when you file Chapter 7. And that's dependent on what state you live in. Tennessee's got a set of exemptions, Georgia, Alabama, and there's a federal exemption. It gets kind of complicated, but I'll just speak to Tennessee by way of illustration. Depends on the state you live in. In Tennessee, basically, you get to keep $5,000 of equity in a house. Unless you're a couple, then it's $7,500. If you have custody of minor children, it could be $25,000 to $50,000. Or if you're over the age of 62, it could be anywhere from $12,500 to $25,000. It gets a little technical there, but if you don't have too much equity, you keep your house. And on the personal property side in Tennessee, it's a little simpler. Basically, you keep $10,000 worth of personal property, which is basically everything other than your house, which would be your car and your furniture, and your furnishings, and your personal possessions. And for most people, they don't have over $10,000. But if they do, then they could go into a 13 and pay something to their creditors and avoid losing those assets. If they've got too much equity in their house, they go into 13 and pay the value of their equity of the house and not lose their house. Also, sometimes people have certain debts that they cannot deal with in a 7, some debts that are not dischargeable, like tax debts, and they can deal with those in a 13. They do a 13 if they're behind the house, behind the car. If they go into a 7 and they're behind their house or behind the car, that won't solve that problem. If they're current and don't have too much equity, they're going to be okay. But if they're behind, their only thing that's going to solve that is a 13. Also, another reason is you can only do a 7 once every 8 years. And so if you filed a 7 recently, you can't do another 7. You may have to file a 13. So there's a lot of reasons that you maybe could or can't file a 7 that you would have to or need to file a 13. It gets a little technical. Every situation is different.
And you just have to sit down with the folks and figure out what they have and where they are and what plan best fits them.
Right. It's all very individualistic. It's hard for people to take someone else's bankruptcy experience and translate it into their situation, because every situation is different.
Now, let me ask you a question. Of the debtors you have represented, do you find that some people actually have a desire to pay back what they can, as opposed to just trying to get everything totally discharged and not be anything out of pocket?
I think most people desire to do that. I think that was maybe more prevalent, 20 or 30 years ago, or 40 years ago when I started practicing. But I think generally people do want to pay their debts. Most of my clients that come in, they do not want to be there, do not want to not pay their debts. And the last thing they really want to do is file bankruptcy. And so they have a great desire to do that, but sometimes they simply cannot. And sometimes people will elect to go into a 13 and pay their creditors when they could file a 7 and not pay them. So yes, I do see a lot of that.
And I think from my bankruptcy days, I do remember vaguely that our bankruptcy court here, back when I was involved, had a high number of Chapter 13 filings, more so than across the country. Is that still the case?
That's still the case. I don't know what the percentages are, but we're among the top. First of all, we're usually the top 4 or 5 states in the country for bankruptcy filings, period. And a lot of that is because we file a significant number of 13s rather than 7s, so much more so than around the country. You're right, because people want to pay their debts back and want to make every effort to do that.
And I also think I remember from my old days in bankruptcy that we have a high incidence of bankruptcy filings in this area, more so than across the country. That's
right. Here in Tennessee, Georgia, and Alabama, again, are usually the top filings per capita anywhere in the country. And there's some reasons for that, but people file a lot of 13s. And sometimes people start a 13, usually it takes 3 to 5 years, and something will happen. They'll lose a job or have some medical bills, and they'll have to get their case dismissed. Then they'll come back and restart it and succeed the second time. So if it doesn't work the first time, if you get back on your feet, you can still try it again. So that kind of makes the filing numbers go up, which is a good thing because they keep trying to file it. Often they do succeed.
So actually, you can potentially have several goes or more than one go at a 13.
Yes, as long as you're acting in good faith with the court and your circumstances just overcome you, and you come back and you've got new circumstances that show you can now do it. Theoretically, you can say try 13 as often as you want. It sounds maybe that's subject to abuse, and it could be, but if people are operating in good faith, the court will give them another chance if they can now do something on their 13 payments.
I know people always have a question about if I file any form of bankruptcy, are there things I can keep that I own? What am I going to lose through the process?
Right. Well, this kind of goes back to but he's talking about the Chapter 7 and the assets, the exemptions that you have, which really primarily applies in Chapter 7. And again, if you own real estate, and again, the exemption statutes are very different state to state. In Tennessee, in order to exempt any real estate, it has to be your home. You have to be living in that home, and it has to be real estate. It can't be just a mobile home. It has to be some land that you're living on. It could be a frame-built house or a mobile home, but you have to be sitting on some land, and you can exempt it up to the dollar amounts I mentioned based upon whether you've got children or based on your age. In Georgia, it's pretty liberal. It's like a $22,000 per person exemption in real estate. And I guess it's kind of technical. In Georgia, that homestead exemption can apply to a mobile home and not limited just to real estate. Georgia exemption statute is a little different. It's a little bit more liberal than Tennessee's is. So it just depends on the state you live in. And it gets even more complicated. I don't get too complicated. You have to be living in the state where you're living now for the last 2 years continuously, well, that state's exemption statute to apply. If you have not, they go back and look and see what the exemption statute of the state was between 2 and 2.5 years before you file. And this gets very convoluted and a lot of work for the lawyer, but we'll figure it out.
Now, so actually, it sounds like it's advantageous not to have much equity in your home.
Yeah, if you file a 7, have too much, you could lose it. Right. That's right. That's when you either don't file or you file a 13. But sometimes people, I get a lot of situations where somebody's maybe in their 60s or 70s, they've come in there on Social Security, and they got a $100,000 house, and they got $50,000 of credit card debt, and they can't, if they could afford to pay it all back in a 5-year 13, that would be fine. But they can't afford to do that. If they file a 7, it will guarantee the trustee will sell their house. So they just can't do anything. So you don't want to, because doing nothing probably won't cause you to lose your house. If you file a 7 in that situation, it will guarantee the trustee will take your house. So sometimes the best thing is to not file if you've got those situations.
So there's some situations filing bankruptcy is not the indicated thing.
Right. Sometimes it could be an unmitigated disaster, depending on, that's not very often, and the attorney is going to be able to tell you that, but it could be very not a good day if you did it.
You have just mentioned the office of trustee. Can you tell us a little bit about what a bankruptcy trustee does? That's
a good question, Phil. And again, we have Chapter 7s, which are the liquidation, where you file and just get a discharge of your debts, which is just about everything except taxes and student loans and certain things, and alimony, child support you can't discharge. In that case, a trustee is appointed by the court, actually by the Department of Justice, the U.S. Trustee's Office, and they're in charge of your case, and they are preside at that meeting of creditors, and they're looking to see if you have too many assets or don't have too many assets. And if there are too many assets, then the trustee's job is to liquidate those assets and take that money and pay it out to creditors so that they get some kind of distribution from your case. And they, of course, look to be sure that you're complying with the rules and being truthful and have listed all your assets and so forth. There's one standing 13 trustee. Her name is Kara West, and it's her responsibility to administer all of these 13 plans where money is coming in and paid to her office, and then her office distributes this once a month to the creditors. So she's the only 13 trustee, and they have, I don't know the number, it's the tens of millions of dollars a year that go through her office. It's a very big operation. She has a very large staff. So we have one 13 trustee and two about to be 5, 3 new, will be 5, 7 trustees very soon.
So the trustee, I take it, basically represents unsecured creditors.
That's exactly right. That secured creditors are creditors that have like a lien against a car, or they got a lien against your house, or a lien against your furniture. And so the law or the code pretty much assumes that they're going to take care of themselves. So the trustee is looking out primarily for the interest, you're right, of the unsecured creditors. That's the small creditors, maybe an individual or a small loan company or a bank or credit card company or a doctor bill. And that trustee is looking out to be sure that their interests are protected and that the debtor is doing what they have to do to pay the money that goes to the creditors.
Now, I also know that from my previous experience that the trustees, particularly in a 7, if they think some payments were made to certain creditors within a certain period of time within the filing of bankruptcy, they can go try to set aside those as preferences. So all the unsecured creditors take an equal, pro rata equal shares.
That's exactly right. It's something called a redistribution theory, or it's a preference transfer. And what the law does, without looking into the debtor's intent or thoughts, they draw a line during the last 90 days. If the debtor paid more than $600 to a creditor, it generally applies to unsecured creditors. If they're making the mortgage payments, house payments, it doesn't really kind of matter. If they went out and paid $1,000 to a doctor, or $1,000 on a medical bill or a credit card or something like that, then the Chapter 7 trustee has the duty and the authority to go back and sue that creditor and bring the money back into the bankruptcy estate, and, as you say, redistribute it equally. They think it's unfair for that creditor to get favored in that 90 days. That money comes back in and gets redistributed.
How often in your experience, I know probably a lot of debtors don't even think about making what would be a preferential payment during that 90 days, the way it works out. How often have you found that trustees do go after those funds? Or sometimes is it practical given the amount of money involved?
Well, it may not be. And again, let me say, it doesn't necessarily mean the debtor did anything wrong. This isn't that the debtor did anything wrong. It's just a provision of the bankruptcy code to try to create more fairness. So it's not wrong to pay your debts, but depends on who the money was paid to. Most trustees, unless it's well over $1,000, are not going to pursue that. Right. And actually, if you pay anything, any amount of money back to a family member within 1 year prior to filing bankruptcy, the trustee can go back and recoup that money from your family member. That's the provision that tends to cause more angst and anguish among debtors than anything else, to think that they may sue mama or my brother or my aunt. Again, if it's less than $1,000, we tend to say the trustee's not going to care about that. If it's more than that, and we just have to deal with it. Or if it's a lot of money, then they could file a 13 and avoid that from happening. Sometimes we take a 7 problem and go into 13, and we pay a little bit of money makes it go away.
Right.
And it's all legitimate. It's just that the creditors don't get their money through the 13 process.
Right. Do you have occasions where, I know when a client comes in, you try to get all the information you can, but you have cases where situations where you find out different facts later and have to make adjustments, convert your plans, and those kind of things?
The biggest challenge that I have as a debtor's lawyer, and I think all of us debtor lawyers have, is to get all the information that we need. And it's a very difficult process. And even, there are some people that may come in and not tell us the truth, but more often it's they don't understand the question, or they weren't thinking. And so we're challenged to try to ask sometimes the same question 3 or 4 different ways to prompt their memory to be sure they tell us all the information. And sometimes it's simply a mistake or an oversight. It's very important to get all this information correct on these petitions. If the court feels that you've willfully failed to list something or disclose something, it could be a debt or an asset, then you can ultimately lose your discharge. Right. I think it was egregious enough that. But, when people make simple mistakes, but it's really hard to get all this information out. People, we talk as lawyers, we have our own language, and so we have to ask these questions more of a layman's language, because they never get asked this stuff. And so I try to get them to give us all the correct information. But despite of what you do, they'll forget, or just it won't get down there. But that's very important. That's the most important task I have, is simply to get all the facts out on the table when I first meet with a client. Because if they've done something like a transfer, or we don't want to do that, or maybe we need to wait a while before we do something, and maybe in some cases, waiting 3 months may make a problem go away, because certain things depend on how long ago it's been that you've done something. Right. So, but to get down there and, one good example is if you've transferred property away in the last 4 years, like you put your house in your mother's name 2 years ago, and you don't tell that you don't tell me, and I don't know how to advise you, and the trustee figures it out, and they go get the house with your mother. So,
oh man, we're already in break time, Mark, and we've just gotten started. Okay. We are talking. This is Legal Bytes, and we're talking to Mr. Mark Young. If you want to call him for a consultation, his office number is 423-870-5225. We'll take a break and be back with you shortly. Thanks for being with us.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM. 3, 2, 1. Chattanooga Radio, AM 1240 and 92.7 FM's news now.
Chattanooga cops and the FBI have just released photos of a man they say robbed a bank at North Point Boulevard Tuesday morning at 8 o'clock a.m. It was a Bank of America. The photos apparently show the man brandishing a handgun. He's a black male. The police are asking the public for help identifying him. 2 shootings in Chattanooga overnight. The first happening at 9 o'clock on Brainerd Road. A victim was shot. The second, gunshots rang out at 34th Street at 6:30 in the evening. Neither victims were killed, and in both cases, the gunman is still on the loose. Just after 9 o'clock at night, a driver lost control of his car and smashed into a tree on Birchwood Pike. Hamilton County Sheriff's deputies said the driver was dead by the time they got there. An investigation is underway to determine the circumstances of the crash. If you're in Soddy Daisy, your property taxes may go up by just under 10 cents. Soddy Daisy officials considering a property tax increase of just under 10 cents per $100 of assessed valuation. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect more heat and humidity out there through your afternoon. Highs 92 to 94. Spotty shower storm may pop up, but most of it staying dry. Tonight, muggy. Lows only 72 to 74. For Wednesday, more of the same. Highs 92 to 94 with showers and storms more likely by Friday. Tired of the pressures and hassles of car shopping? Come see what more people are making the short drive to Jackson Chevrolet Buick GMC in Lafayette or online at jacksongm.com. That's Jackson Chevy Buick GMC in Lafayette. And I'm Source 12 Chief Meteorologist Patrick Orr on Nooga Radio AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune, Williams, and Ashley P. LLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley P. LLC is here to help you and your business succeed. MWALawFirm.com. That's MWALawFirm.com. Call 423-756-6400. That's 423-756-6400.
This is Thomas DeMoss with Keller Williams Realty. I am a realtor in Chattanooga. We list and sell homes, work with buyers, work with home sellers. I have been involved in real estate for over 10 years. My background is as a real estate investor. That is what I bring to the table, is that real estate investor mindset. My job is to help you sell your house for the most money, employing the best marketing strategy and walking you through what can be a rather stressful process. So we are encouraging people who are on the fence or even thought about selling their house to give us a call. There's no obligation. We're just here to kind of have a conversation, let people know what the process is like, what the market is like, what values they can expect to receive. We work with buyers as well. I also have a buyer's agent that works exclusively with my buyers because we want to give our clients as much attention as we can. My cell phone number is 423-364-0028. Our website is northriverpropertygroup.com. That's northriverpropertygroup.com. We'd love for you guys to call us.
I have the best steak selection in town. The name of the business is Don's Meat Shop, and I'm Donnie Raines. Just ask for Donnie. I make over 20 different types of sausages. Most of them are great for grilling. We have the best selection, best quality. We have the hard-to-find items. Don's Meat Shop.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree? Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
This is Fielding Ashley, your host today on Legal Bytes on the Nooga Radio. And we're delighted to have with us today Mr. Mark Young, who is a certified expert in consumer debtor bankruptcy. And Mark, it just seemed like we got started in the first half of this segment on bankruptcy questions. So we may have to have you back. I don't know how much we're going to get covered, but we would appreciate you being here. If anyone out there that has questions they want to ask Mark about on the air about your particular questions, our number here is 800-8949. And if you want to follow up with Mark later, his office number is 423-870-5225. His staff will certainly be happy to help you and assist you. Mark, I believe we were started talking about things you can keep in bankruptcy, and I got sidetracked on trustees. But I think people particularly would be interested to know how I can keep, if I get behind on my house payment and my car payment, how can I keep my house and how can I keep my car and those kind of things?
That's a good question. That's a typical Chapter 13 case situation. And when people get behind on their house, a lot of times the mortgage company will not work with them. And how that works, of course, they have to have income to fund the plan. But assuming they've got regular income and can fund the plan, it could be a job or Social Security or retirement or whatever they could be self-employed. Let's say they're $10,000 behind on their house. The house payment's $1,000 a month. We'll figure out a plan payment, and out of that plan payment, it's going to be going to a 13 trustee, and that trustee disperses the money. If they're working at a regular job, it'll be done by payroll deduction. If it's not, they get a Social Security retirement check. It can be drafted out of their bank account, or they can just send it in if they're self-employed. Anyway, out of the money that goes to the trustee, the plan will say the regular ongoing house payment will get paid. We can't really change that on a long-term mortgage. Then if they're $10,000 behind, they'll get a check each month so that by the end of the 5 years, that $10,000 arrearage is paid off. When they come out of the plan, they're contractually current, and there'll be an order that says so, and then they'll be sent a letter by the trustee saying, congratulations, your case is completed. We paid it through October. You start with a November payment. Now, cars, generally speaking, the plan lasts no more than 5 years. Most people don't owe more than 5 years on cars, although I'm seeing a lot of people now that have financed their cars for 6 and 7 years, and they do still owe more than 5 years on their car. If they owe more than 5 years on their car, if they've got 5.5 or 6 years left on it, then probably we're going to do like the house. We're just going to make the regular monthly payment on the car, say it's $500 a month, and catch up any payments they're behind. And when the plan's over with, they'll have to pick up the last 6 months or a year on the car. But for most people, 5 years, we'll just pay that balance in full in the plan with a monthly payment, so they'll come out with their car paid for. One of the changes that they made in 2005 is now what you have to pay on the car creditor on their claim is based upon how long you've owned the car. If you've owned the car for over 2.5 years, I don't want to get too technical, or maybe you had a car paid off and went and borrowed money on it, then you just pay the value of the car as a secured claim. In other words, if you have $10,000 and the car's only worth $6,000, and you have those circumstances, you just pay $6,000 plus interest, and usually the interest is no more than 7.5 or 8%, although the contract may be 18 or 20%. And the difference between the $10,000 and the $6,000 value gets split off and is treated as an unsecured portion of the claim, along with the credit cards and medical bills. And it may be in a category that's getting paid 10% or 50% or 100% and gets no interest. But if you've got a car that you purchased within the last 2.5 years, you can't do that. Whatever the balance is, you've got to pay it off in the 5 years. You can still knock down the interest, maybe 7 or 8%, but you got to pay the full amount if you've had less than 2.5 years.
So you've had a car for 2.5 plus years. You can do what we used to call a cram down, where you get down, this is the actual value of the car, not really what I actually owe on the car. And that can be a real advantage in a Chapter 13.
Exactly right.
And now you can't do that on your house.
No, you can't do that on your house. There's something called an anti-modification provision in the bankruptcy code that says if it's a long-term debt on your residence, where you live, you can't modify the house payment. You just got to pay the payment, whatever it is. You can catch up the arrearage, but you can't change the payment.
Now on a 13, if you weren't able to make your house payment before you went to bankruptcy, you go into a 13, but you got to make your basic payment and you got to catch up on the arrearage.
Right.
So you're going to have to start really paying more than you were paying before.
Right. And sometimes people have gotten behind because of circumstances, have slowly gotten behind, or they were out of work because of an injury or, lost a job. As long as at the present time they can afford their new plan payment that does all this, then they will generally approve the plan, and you can pay going forward and catch up what you've missed on the house in the past.
Okay. Now, what if you get behind on your car payment? How does that work when you file your 13, if you're in arrears on your car payment?
Well, the arrearage is treated differently on a car. It's a good question. If you're not making the maintenance payment on the car, if you're just going to pay it off, it doesn't really matter how far behind you are. You just pay that balance of that claim or the value of the car, depending on how old the car is, how long you've had it, and it's just paid during the plan. So you don't have to worry about catching up the arrearage. The only time you have to worry about catching up an arrearage on a car is if it had more than 5 years left. You're going to pay 5 years instead of 6 months or a year left. Then you'd have to catch up the arrearage to bring it contractually current, like the house, and finish it off after the plan's over. You don't have to worry about the arrearage. This gets very technical and very confusing, I know.
Do you find that people have a hard time actually paying more through the 13 than they were paying before they got into 13, or do they become more disciplined?
Well, one thing, most people find that the 13 is going to be a great benefit to them. Sometimes the 13 payments aren't going to help them. Most people it does, and some people will sit there and look at me like they just saw an alien because they can't believe what I'm telling them is true because it seems so magical. And it's not that way for everybody. But if they, I'm about to lose the question there.
They're having to pay more through the 13 than they were paying before.
Yeah. Usually, always they're paying less than they were paying before.
Okay.
It's very rare that it's more.
Because they're paying less on other things.
Paying less on other things. And a lot of times on the unsecured debt and the credit card they're making big payments on, they're going to pay them. First of all, the interest is going to stop. On the credit card's interest is going to stop. And that's a huge deal. If you're paying 16, 18, or 20% and turn that interest clock to zero, and even if you're paying 100%, it will save you money. And it's oftentimes they're not paying even 100% of their debt back. So if they're paying 70% or 40%, then that's how they're able to afford this. And again, that's based upon whether they have too many assets or what their disposable income is. Obviously, if they make a lot of money and can afford to pay 100%, they have to do that. And their unsecured debt might be $10,000 or $100,000. It makes a big difference. But the question is, what can you afford to pay back? And maybe wind up being 5% or 100%.
Right. Now, let's talk just a minute about discharge. How does discharge work in a 7 and a 13? This 7, what gets discharged? In other words, it's wiped out. What doesn't on a 13, if you complete your plan, what gets discharged and what doesn't?
That's a good question. And they changed
I appreciate you saying I'm asking a good question.
Well, you are. It is a good question. And they changed that in 2005. There are different discharge provisions for a Chapter 7 than there are for Chapter 13. It used to be a lot of debts that you couldn't discharge in 7, you could discharge in 13. They took a lot of that away. Let me just say what you can't discharge in a 7. You can't discharge student loans, penalty, or any interest or principal can never be discharged in any kind of bankruptcy. Theoretically, the bankruptcy code talks about a hardship discharge, and if people go out and look on the internet, they'll see something about the code saying there's a hardship discharge in bankruptcy. Let me just say it's my opinion, the opinion of just about everyone else that does this, that I do, that if you're breathing, you don't get a hardship discharge. It's really almost impossible to obtain legally the way the law is now. So practically, you can't ever discharge the student loans. You can't discharge sales tax. You can't discharge any kind of alimony or child support allegation ever in either bankruptcy 13 or 7. Now, income taxes can be discharged. There are rules about that if it's an income tax debt. And
you mean I can get rid of some I owe the IRS?
If it's old enough, there are a lot of technical rules, but if basically, and just say if the tax first became due more than 3 years ago, if it's for income tax, if the return has been filed at least for 2 years, and you're not a tax protester, I don't think I'm leaving out any of the exceptions, then you can discharge old income taxes where the return has been filed. That's true. And I've discharged, people have been able to discharge hundreds of thousands of dollars if they're just really old taxes. But if they've been incurred or came due in the last 3 years, those are accepted from discharge in a Chapter 7. And sales tax, you never can discharge. They have withholding taxes like the 940, 941 withholding taxes that didn't pay their employees withholding taxes. Those are never dischargeable in any bankruptcy either. But the income taxes can be dischargeable under the right circumstances. The same is true if you go into a 13. Those taxes that came due in the last 3 years, if the returns were timely filed, have to be paid. If the other part of your IRS debt becomes unsecured, you don't have to pay whatever percentage you pay to the unsecured creditors. So, a lot of times people file 13s just to deal with IRS problems. It can be a reason that you need to do that, or to pay sales tax, which you can never discharge. I'm trying to think what else you can't. That's certain debts gets undischargeable, like the ones I've talked about. But certain debts like are non-dischargeable if the creditor comes in and timely objects. This would be like if you intentionally harm someone, if you just maybe took a ball bat to their car or punched them out or something like that, intentionally harm someone, you can't discharge that if they object. The big category that you can't discharge in Chapter 7 if someone objects is fraud. If you've done something in a business deal or selling your home or selling a car or whatever you've done and you've committed fraud or misrepresentation. Now, we lawyers, people think fraud is criminal. It's civil and criminal fraud, as you know. But fraud is just a legal term for misrepresentation. If you misrepresent something or fraudulently represent a fact and cause someone to incur a debt, then if they object in a 7 or 13, you can't discharge that type of debt. So that's pretty much, and there is one thing that's different about 7 and 13 that has a lot of application in the domestic relations area. If a couple gets divorced, oftentimes they have debts. And in the marital dissolution agreement, usually it will say, the husband pays these debts and holds the wife harmless, and the wife pays these debts and holds the husband harmless. And if that's in the property settlement agreement, it's the nature of property settlement, not the nature of support, you can never discharge that in a 7, but you can in a 13. So if you're a husband in order to pay the wife's debts, it simply is just a property settlement, not in the nature of support. You can file a 13 and pay whatever you can afford to pay on that and discharge that obligation and get out of that.
And did you find that frequently that 13s are used for that purpose? Because usually people get divorced have all kinds of debt.
Right.
This has to be assigned to the parties.
I have a lot of people that sometimes file 13s for that very purpose. Now, sometimes both husband and wife are having to file a Chapter 7 anyway, so it's not really an issue. But sometimes if your ex-spouse is likely to be vindictive, which can happen in that arena, then that's the safe way to go, so they can go back, because the court can hold you in contempt. The divorce court can, if you haven't done that. Because this doesn't apply to child support, alimony support issues, but if it's just a property settlement matter or just money you have to pay that's not related to support, you can discharge that in a 13. So that makes that choice of chapter very, very important. This is a change in the law, too, that happened in 2005. And also, when have someone come to see me and they're in the middle of a divorce, there's a potential for this happening. I said, you got to get divorced first, because that obligation isn't created, as you know, until the divorce decree is entered. So get that decree down, then we'll file. Not the other way around, because you can't do anything about a debt that's incurred after the 13th file.
Right. Now, what if I know a common problem? A lot of people drive cars in Tennessee, even though they're not supposed to, without liability insurance. Or they don't have enough liability insurance. And what if I have a car wreck and it's my fault, and I get sued about that? Does bankruptcy do me any good if I go to bankruptcy to try to relieve that obligation, that liability for the injuries I've caused?
Yes, you can discharge that. The only exception to that is if you were under the influence of something and caused that injury, then it may not be discharged. But otherwise, the civil liability for negligence or being at fault in a car accident is dischargeable in 7 or 13, just like any other debt. But you touched on the Financial Responsibility Act, which in Tennessee and all states have a law like that, requires you to carry insurance. And so if there's a loss like that and you're liable for it, that party or their insurance company can report to the Department of Safety, and they will revoke your driver's license privileges. And so filing a bankruptcy as 7 or 13 brings you in compliance with that Tennessee Financial Responsibility Law and entitles you to reapply and get your driver's license back. So that's a very powerful use, because it's very important in this society to be able to drive a vehicle.
Because they consider that's taking responsibility.
It's taking responsibility because you have a legal right to file bankruptcy. So, and there's been cases in the state of Tennessee has to honor that, and they have to reissue your driver's license. They have to go through the application process with the Department of Safety and so forth, but they have to do that once you file bankruptcy.
Did the Tennessee Department of Safety fight that for a period of time, or is that
many years? That's been basically the status of the law, black and white law, for 25 or 30 years.
So you just told me something I didn't know. I didn't know that would work that way.
A lot of people don't know that. It's like, but and if it's another state too, if your driver's license is revoked in Georgia, it's the same law.
So if you do have an automobile accident and you don't have liability coverage or enough liability coverage, bankruptcy then is sort of some form of bankruptcy. Is one of the things you probably need to take a look at.
Yeah, that's right. It would help you get your driver's license back, and usually people in that situation have other debts also.
Right.
Yeah, it's just a simple matter to get your license back once you file the case.
Now, I know people are always concerned about, if I file bankruptcy, how's this going to affect my credit? Is it going to be a big black mark against me forever, and I'm never going to be able to get credit? And I won't be able to really live and ever get a credit card and all those kind of things. What's your experience there?
Well, generally, bankruptcy filing 7 or 13 is reported from 7 to 10 years on your credit record from the date you file it. There's sort of a difference in rebuilding. Once you file a bankruptcy, you have to start the rebuilding process. You file the 7 or the regular liquidation, it's going to be over within about 4.5 months. So you can start rebuilding in 4.5 months. The 13, you can't start rebuilding until you pay it off, which is going to be 3 or 4 or 5 years. That's sort of a disadvantage to being in a 13, but it's just kind of is what it is. But once you start the rebuilding process, whether it's in 3 or 4 months or 3 or 4 years, most people find in a year or two after the 7 or a year or two after completing a 13 case, they're slowly able to bring their scores up. They have to use credit responsibly that's reported to the credit bureau in order to bring the score up. The best way to do that, I understand, is to get a secured credit card. There are banks and credit unions. If you put up a $500 deposit, they'll hold it and they'll give you a credit card that's got a $500 limit. And nobody knows that's how it works, but if you charge on that and pay on it, it gets reported to the credit bureau, and you're a responsible bill-paying member of the credit, a borrowing community again. And slowly, over a period of time, your score is going to come up. So for most people, if they work at it and use credit responsibly in 2 or 3 or 4 years after they get out of the 13 or 7, they're going to be able to start doing things again. Some people it's quicker than others, some it's longer, but it's not until it comes off your credit record. A lot of people are buying houses 2 or 3 years after a Chapter 7, or buying cars 2 or 3 years after a Chapter 7. It just takes a while.
But it's not the total black mark.
No, it's not as bad as
people may have in their minds.
No, it's not like not an 8 or 10 year walk in the dark. And oftentimes they're going to get their credit restored much quicker than if they didn't file bankruptcy. Because if you've got all this stuff on there and all these debts, unless you pay those debts off, your credit's not going to get any better.
Your credit will just continue to be messed up because all these continues to get reported to the credit bureau.
Right.
So now, one question is, people always ask, do I have to list everything I owe, all my debts? Can I pick and choose?
That's a good question. And a lot of people think that's the law or hope that's the law, but it's not the law. If you file a bankruptcy petition, 7 or 13, you have to list all of your debts. It's like you have to list all of your assets, and you have to sign something under penalty of perjury saying that you've done that. So you can't just pick and choose. You have to list everybody. Now, if you file a 7 and you list everybody, say you list, Dr. Jones has been your doctor forever, you're going to have to list him. But once you file the 7, if you want to pay him later, that's up to you. You can do that. Now, 13 is a little different. Sometimes we'll put in the plan to get permission to pay him outside of the plan, but you have to list everybody. They have to be dealt with in some fashion.
I think we've covered this before, but the question is, how often can I file bankruptcy?
Okay, that's something also they changed in 05, which is again the regular bankruptcy is every 8 years. Okay, and it used to be 6, but now it's every 8 years from the date you file the prior Chapter 7. A Chapter 13 can be filed at any time. One of the changes that I dislike the most about the law when they changed it, if you're coming in, you file a 13, and it's been less than 4 years since your prior Chapter 7, you get to file a 13, but you don't get a discharge at the end. What does that mean? That means that in a 13, generally speaking, if you propose to pay, plan says you're going to pay 20%, at the end you get a discharge to discharge the balance of the debts. That wouldn't happen if your Chapter 7 was within 4 years you're filing this 13. And that means either people have to pay 100% or they go through a 13 and don't get out of debt.
Mark, we hear the music playing. We really do appreciate you joining us today. Mark Young, who is a certified expert in debtor consumer bankruptcy. Mark's number, if you need to call him, is 423-870-5225. I'm Fielding Ashley, filling in for Jim McCoon today on Legal Bytes on Nooga Radio. We will sign off, and we will see you next time.